joined with Greg Remmenga here with some more free legal advice. Today we're going to be discussing some options you may have to do if you can't necessarily afford to pay your injury claim, and bankruptcy is one of those options, but sometimes that's not necessarily a good thing.
Right. Well, we all know, based upon what we've discussed, that the person who caused your accident isn't going to pay your medical bills, pay your lost wages, pay anything to you until you get a settlement or a jury verdict. During that time, you need to get all of your medical care taken care of. You're going to have bills piling up. You may have lost income. So bankruptcy may be thought of as an option to eliminate those bills and debts and the medical bills. One of the problems with bankruptcy, though, is that the bankruptcy trustee then owns your personal injury claim, because it's an asset of the bankruptcy estate.
Gotcha.
So therefore, the bankruptcy trustee now dictates what we'll settle for, what litigation we're going to do. The whole litigation process, you have to participate and you have to be involved, but you're no longer in control. That could end up being a good thing for you. It might, though, take the control out of your hands, and the bankruptcy trustee might settle for something that you wouldn't be willing to settle for, because the trustee now owns the claim.
Right.
A second issue is that anytime you file bankruptcy, there's an automatic stay. That means that nobody can pursue litigation against you, and you can't pursue litigation against somebody else until the stay is released by the bankruptcy court. So therefore, if you're planning, oh, I'm going to file this bankruptcy because my court date's in 3 months, it puts a stay on everything, which means your case can't go forward and people trying to collect their debts can't pursue you, but it puts a hold on everything. So these are just things that you need to think about. You have to make sure that you disclose your potential injury claim to the trustee. The trustee then decides whether he's going to accept that as part of the assets or whether he's going to relinquish it back to you. If he relinquishes it back to you, you proceed with your case as normal. But the trustee may take control of it and the case is no longer in your hands. So there are things that we need to weigh out. We need to make sure that if you're going to file bankruptcy, the bankruptcy attorney and the personal injury attorney coordinate and try to figure out what's best for you. Don't file the bankruptcy without telling your personal injury attorney, because they interact with each other and can affect both.
Absolutely. So bankruptcy, not necessarily the right answer. It could be, but make sure to kind of get in touch with as many people as possible to come up with the right solution.
That's correct.
All right. Thanks so much, Greg. If you have any questions for Greg, you can contact him with that info right there on your screen.